Well, everybody, thank you for joining us tonight. Welcome to our virtual Wayland Library event. My name is Andy Moore. I'm the Assistant Director of the library. Tonight, we're very happy and delighted to have attorney Harry S. Margolis here to speak to us about trusts, which is the subject of his latest book, The Baby Boomer's Guide to Trusts, Your All-Purpose Estate Planning Tool, which is available at the library and on Amazon. Mr. Margolis has been representing seniors, individuals with special needs, and their families since 1987. He has helped thousands of clients pay for long-term care, grapple with the incapacity of a family member, and plan for safe and productive futures for their children. For 3 decades, he served as editor of the Elder Law Report, a monthly newsletter for attorneys, and his leadership in the field has been recognized by his peers as he was selected to be a fellow of both the National Academy of Elder Law Attorneys and the American College of Trust and Estate Counsel. Mr. Margolis' passion is explaining complex legal issues to clients in his practice, as well as to consumers online. You can find Harry at Margolis & Bloom, LLC, and also at askharry.info, where he answers consumer questions, empowering people with the knowledge they need to achieve the best legal solutions. Thanks again to Harry for being here tonight. Before Harry gets started, I have a couple of Zoom housekeeping notes. First, we are recording this session for broadcast on Waycam, the local cable access channel, and for the library's YouTube page. So you'll be able to watch it and share it with friends. I am recording my video, Harry's video, and his slides. Second, Harry will speak for about half an hour, and then we'll have time for questions and answers. Feel free to put your questions to the Zoom chat at any time. And my colleague, Courtney Michael, behind the scenes, being the power, will read them aloud. Or feel free to unmute after the presentation to ask your question aloud. Just note that your voice will be part of the recording. And we would like you to stay muted until that time, so as not to hear any phones ringing, doors slamming, dogs barking, etc., all those other Zoom pleasures. So that's out of the way. We're ready to get started. Over to you, Harry.
Okay, thanks, Andy. So I'm going to share my screen because I have some slides. So let's see if that'll work. Can you see my screen? Oh, might have, everyone's muted. Courtney.
Yes, we can see your screen.
Okay, great. Okay, so I wrote the book that Andy talked about because I got a lot of questions on my Ask Harry's website, askharry.info, about trust. Now, admittedly, most of those questions were really in 2 areas. First, how much should trustees be paid, both from beneficiaries who think they're paid too much and from trustees who want to make sure they do get paid, want to know how much they can pay themselves. And the other area of questions is taxes. How are trusts taxed? So we'll get into both those questions. But first, I wanted to really give an introduction to trusts. And let's see if I can get these slides to actually go where I want them to proceed. There we go. So trusts are an incredible tool. And they're an incredible tool for estate planners to do just about anything, but which also makes them confusing because virtually no 2 trusts are the same because they're flexible. You can create a trust to do just about whatever you want in estate planning. But these are, on the slide here, are really the kind of the main reasons to use a trust. And the first is they're a very good system for managing assets. They keep it all in one place, and trustees who's in charge, and we'll get into the players and trust in a second, manage it for the beneficiaries. So that really helps for asset management. And that's really important in case of incapacity. So whether someone's already incapacitated and you want to manage their assets, or any of us could become incapacitated, especially as we get older. So having funds in trust can help with that. And people often ask, well, I have a power of attorney. Why do I need a trust? Don't they do the same thing? And the answer is trusts just work better for a couple of reasons. One of the main reasons is that financial institutions are more comfortable with them. So we find that people with a perfectly good, durable power of attorney, they go to Fidelity or Bank of America or some other financial institution, and the institution doesn't honor it, or puts them through a whole ringer before they'll honor it, and they're just more accepting of trust. The other thing is one of the sort of tasks of setting up a trust is to transfer title of property into the trust, and once you've done that, it's all in one place. So whoever's going to take over for you in the event of incapacity has everything already basically in order and consolidated, rather than having to go around to half a dozen different banks and financial institutions to do it at the point of incapacity, when they're probably dealing with a lot of other things. Trusts also avoid probate. They can help reduce taxes. We'll maybe talk a little more about that. They can provide for asset protection. So they can be designed to protect your assets from creditors. Now, I'll say a few words about that. If you want to protect your own assets from creditors, you have to do it through a pretty restrictive trust, or go to some of the states that now have what are called domestic asset protection trusts. So have a trust created in New Hampshire or South Dakota or Nevada or Delaware or Alaska, or some of the big states for that. But if you want to create a trust to protect your assets that you're leaving your kids from creditors, or in the event of divorce, then that's pretty easy. You can just create a trust for them, and when you either fund it during life or during death, those trusts that you're creating for someone else, it's pretty easy to create an asset protection trust. They're used for benefit planning, either for people who may need Medicaid, Mass Health in Massachusetts, to pay for nursing home care or for home care or assisted living care, or if often we have clients who receive money either as inheritance from an inheritance or personal injury, and they're disabled and they need to maintain their benefits, and trust can be used for that purpose, which is related also to special needs planning, where you're really creating that trust for somebody else who's disabled, usually. So usually a child or grandchild. Trusts are especially important in blended families. So when people get married or don't get married, but they're in relationships and they're bringing children from different relationships together, things often go in there are often unintended consequences of this. I mean, if people in later life get together and pool their resources, if they don't plan, usually those resources are going to end up going to the family of the surviving member of that couple. And trust can be used both to provide for the partner, but also make sure that each side of the family is treated fairly. And then finally, keeping in the family, and a lot of what we talked about is all related to that already. But if you leave assets to, say, your child, and then they pass away, those are more likely than not going to go to their spouse, who knows what will happen when that spouse hopefully lives a long and healthy life and gets remarried, and those assets might not end up with your grandchildren. So a trust can be used to make sure that happens. So these are just some of the goals that trusts are just a really good tool for achieving or getting the goals that you want. So to get into the taxonomy of trusts, there are basically three kinds of trusts. That's three kinds of trusts: revocable, or sometimes called living trusts. These are trusts you can change, revoke, nothing's permanent. Irrevocable, once you created it, and put assets in it, it's done. The things follow the rules in the trust. And testamentary, a testamentary trust is a trust that's created in your will. So it won't be funded until you die, and at which point it will be irrevocable. Now, a couple more. So these seem like three very clear, different kinds of trusts, but at the edges, they sometimes merge a little, especially revocable and irrevocable. So first of all, a revocable trust is revocable as long as you're competent to change it and alive. When you die, you're no longer there. The grantor or donor is no longer there to change it, and at which point it becomes irrevocable. But the title might still say John Doe Revocable Trust, and that gets confusing because it's no longer revocable. It's become an irrevocable trust. And then on the irrevocable side, it's about maybe a little less than 10 years ago, I think, the state adopted the Uniform Trust Act, which made irrevocable trusts somewhat less irrevocable than they always used to be. So basically, if you have an irrevocable trust, if all the parties get together, they can change it. And they can change it, there are kind of different ways of doing that. They can change it by agreement. They can go to court for a trust reformation, or they can decant the trust, which is not only for fine wines, but now for trusts. So you can now, if everybody agrees, transfer the assets from an existing irrevocable trust into a new trust that better achieves the purposes of the original trust. And there was a Massachusetts Supreme Judicial Court case that the Kraft family of Patriots fame brought that validated the decanting. So irrevocable trusts are kind of irrevocable now. They can be changed, but only with basically everybody's agreement. So if anybody, everybody has veto power in an irrevocable trust, all the parties at interest. So the players in trust, we mentioned some of these already. So there's the person or people who create the trust. Those are the grantors or donors. There's the people, per individual, more than one individual or institutions that manage the trust. They are the trustees. And then there are the people who benefit from the trust. And those are the beneficiaries. And beneficiaries come, those are the next two things probably should be indented, come in two forms. There are basically current or lifetime beneficiaries, and there are future beneficiaries who are often called remainder men or remainder people. And they, depending on the situation, they may have different interests. So there's actually just a recent case in Massachusetts where a man basically sued his sisters because he was upset. Their parents had put their house in trust, and the trust provided, as a relatively large family, there were three daughters and three sons, that when the parents died, each son would get 10%, a 10% share of what's left, and then the three sisters would divide the remaining 70%. But they didn't tell anybody. And so when the parents died, one of the sons found this out and was pretty upset. And he was especially upset because apparently for the dozen years before his parents died, he was the one who had been maintaining the house, shoveling the walks, mowing the lawn, doing everything else to take care of the house, anticipating that he'd get his, what he thought his fair share of the trust. And so he brought suit against his sisters, who were the trustees, saying, well, you had an obligation to tell me because I was a beneficiary of the trust. And the court said, no, you were a beneficiary, a remainder person in the trust, but you were not what's called a qualified beneficiary because your interests kind of didn't mature, in effect, until your parents died. There was no right to distribute income. You had no right to any of the income or principal in the trust, or to live in the house or do anything else until your parents died, because all those rights stayed with the parents. So he had no right to notice, and he lost the case. The case was actually pretty complicated on lots of other issues, but we won't go into that. So one of the biggest issues with any trust is choosing the trustee. Now, the trustee is as I said, the person or individual or people or institution, and the institution can be a bank, a trust company. A lot of law firms, especially in Massachusetts, act as trustees. This goes back, I was told, to the clipper ships and whaling ships. The captains would leave their assets in trust with their trusted lawyer and go off around the world trading. And since there were a lot of those in Boston, the Boston law firms, all the big Boston law firms have big trust departments, which is not so true in the rest of the country. But anyways, so the question is, who should be the trustee, and who should be their successor? So if the current trustee can't serve for one reason or another, who should take their place, and who should have the power to change trustees? And there isn't one size fits all. So a lot of people don't want to name an institutional trustee, a bank, a trust company, a law firm, for two main reasons, or at least. First, the cost. They don't want to pay trustees fees, and most family members aren't going to charge a trustee fee. Two, kind of control issues. Do you really want to be giving up control over your assets, whether while you're alive or after you die, to some kind of impersonal trustee? And just kind of privacy issues. Do you want people outside the family to know your business? So they choose kind of family members and friends. And I say all those concerns about a professional trustee are valid. But I think the benefit of a professional trustee is that you're going to know that the trust is at least managed correctly, that it's going to be invested appropriately, that no one is going to raid the trust, the tax returns are going to be done, whatever notice does have to be given to beneficiaries and reports will be given, there will be annual accounts. And from my point of view, the cost is worth it. The cost, most professional trustees, depends on the size of the trust, but charge 1 to 1.5% per year, and of the assets under management. And that adds up over time, because you're paying that year after year after year, and you multiply that out, that adds up. But a lot more than that can be lost through mismanagement. In a lot of cases, I think it makes sense to have both a professional and a non-professional trustee. I feel kind of strongly about that in the case of special needs trusts, because the issues can be complicated, and having both means that you have somebody who's making sure things are run correctly, and you have somebody who knows what the needs are in the family. And this is, again, especially true in the case of special needs trusts. And the nice thing, especially when there's a family member who's trustee, is that you can play a little good cop, bad cop. So if you need to say no to a beneficiary who's looking for a distribution, it's nice to be able to blame the professional trustee whose skin is likely to be thicker and isn't going to be showing up at Thanksgiving. So I think it often makes sense to use both. So trustee fees, we talked a little bit about that. They have to be reasonable. That's a little bit in the eye of the beholder. But there are a lot of factors. Again, if it's a professional trustee, they probably have a set fee schedule. If it's a non-professional trustee, you can follow that fee schedule to some extent, but a lot depends on what were the expectations and what were the of the person who the grantor, because they might have appointed a family member with the idea that they're not going to charge fees. If they're going to charge fees anyway, then why not hire a professional? And how much work have they put in? What's their expertise? What sacrifices have they made? What happens a lot, unfortunately, a lot of questions I get on my website are trustees who have put in a lot of work, and now after helping administer an estate and taking care of real estate and maybe rent it out or fix it up to sell. And now that they spent a lot of time, they say, I ought to get paid. And there are a lot of problems with that, because not getting paid as they went along means that they kind of created some expectations that they're not going to get paid. And now all of a sudden they want to get paid for 5 years of work, and they want to get paid by the hour when they might have spent a lot of time, is also difficult. And they also, and then if they're going to get paid anyway, so let's say the trustee spent a long time, and again, I get these questions, cleaning out a house and or fixing up so they could rent it, and managing it. Well, were they the best person to do that? Why not hire a professional to do that, a property management company, a rental agent, things like that, if you're going to pay them anyway? So I usually advise people to find some happy medium. They deserve some compensation, but maybe not, but maybe they should try to save the trust some money by not charging as much as a professional would have charged. And then the power to change trustees is usually very important. So in a revocable trust, or even in many irrevocable trusts, the grantor, the donor usually retains the power to change trustees. So they can usually do it. But then the question is, what happens after they pass on, or if they become incapacitated? Because trustees might not work out, and you don't want to have to go to court to get rid of a trustee. And often they don't work out, not because they're doing something really bad, but the relationship isn't working out. And you want to really have to prove that they've screwed up, or just get somebody who's going to work out better. So it's it's good to give somebody that power. It's probably also good to have some checks and balances on it. And sometimes we really formalize this in the form of what's called a trust protector, which is something that's actually came from offshore trusts, which were used for asset protection before the states that we talked about in the US started these domestic asset protection trusts. But the idea is, for those asset protection trusts, is you had to give up control over the trust and the asset in order to, for it not to be, for your creditors or people suing you, not to be get at it, but you wanted somebody to be able to have some control. So you would name your brother or your best friend or your attorney or somebody else in this role as trust protector, who would have the power to change trustees. And whether you formalize that in that role, or just say that your children or your brother or whoever you want has that power, it's something you need to think about in creating a trust. So I said why I think that it's often a good idea to have a professional trustee, and that's because it's a big job. I mean, it's always, if someone asks you to be trustee, it's a great vote of confidence in your ability and judgment, and it's also it's a big job. So you can say, you might want to say no, thank you for the honor, and no thanks for the job. So so you have what's called a fiduciary duty. So you have to act in the best interest of the beneficiaries, and that can be problematic, especially if you're also a beneficiary, or again, in cases we see where you're hiring yourself to do some work. Is that really in the best interest of the beneficiaries? You have to communicate with the beneficiaries and be transparent. So in the case I talked about earlier about the son who's getting a smaller share of his parents' trust, and he's upset that he wasn't told, he might not have had a legal ground for being told, but he probably had a moral one. And if his parents had told him when they had created the trust what the deal was, then he could have decided he wasn't going to spend 12 years taking care of the house, or if they were going to have or the parents could have explained why they were doing this. We don't know why they did it. Maybe the daughters needed the money more than the sons. Or if the parents really didn't want to have that conversation because they knew how problematic that was going to be, maybe they should have thought about, do they want to create that legacy of letting that fight happen after they die. So anyway, communication and transparency, I think, are very important. Investment, you got to invest the assets reasonably, and that means probably you can't put them all in your brother-in-law's new venture, but you also shouldn't leave it all in the bank. So you need to know something about investment or hire somebody who does. You have to use good judgment. You have to pay taxes or file a tax return. We'll talk about that in a second. I think I have another slide on that. And you have to do an accounting, which is part of the communication and transparency. So you have to report, usually on an annual basis, what's in the trust, what's come in, what distributions you made, what expenses you have paid. Yeah, so let's talk about trust taxation. So if a trust is a revocable trust, it's almost always really easy. So basically, the grantor uses his or her own Social Security number, and as far as the IRS is concerned, there is no trust. So if you look at the trust law, if there's someone else who's trustee, you're supposed to get a separate tax ID number, but I think in practice it's not necessary. So for a revocable trust, just use the grantor's tax ID number and don't make your life too difficult. If it's an irrevocable trust, things get a little more complicated. So if it's an irrevocable trust, you have to get a tax ID number, often called an 04 number for the trust. You have to file a 1041 return, which is like a 1040, but it's for a trust. And the trust tax rates accelerate much more quickly for trust income than they do for personal income. So I can't remember what the schedule is, but you get up to the highest tax level, 39 point whatever percent, at a very relatively low level income. However, for tax purposes, the income follows the money. So even though trusts have a very accelerated and higher tax rate, in fact, they often don't pay taxes. So on it, because if the distributions are made, the concept is the first dollar of each distribution is income, and the further distributions, if the trust has $10,000 of income and you distribute $15,000 during the year, the first $10,000 is income and the next $5,000 is principal. So the first dollars are income. And so if that happens, then the trust reports that $10,000 income on their 1041 return, but then they deduct it for the distribution, and they issue to the beneficiary who received that $15,000 a K-1 for the $10,000 portion that was income. And K-1 is like a 1099, and they just report that on their tax return, just like just like any other income. If they got a 1099 from the bank for interest or from Fidelity for dividends, they would report it in the same way. This can get a little more complicated. There's a distinction between grantor and non-grantor trust. So there are some cases. So if it's a grantor trust, the income actually does go back to the grantor, but the tax on the income goes back to the grantor, even if it has been retained by the trust. So things can get really complicated if you go too far, but the principles I just related are the basic principles. So just figure the income follows the money, and if it's not distributed, then the trust is going to have to pay taxes on it at these higher rates. So one of the problems with trusts is that they don't provide a lot of guidance for the trustee usually. So they say things like distributions may be made to the beneficiary as the trustee deems advisable. Or often they have this language called the HEM standard, health, education, maintenance, and support. So distributions may be made to my surviving spouse for her health, education, maintenance, and support. And so first of all, what does that even mean? Maintenance and support. And second, what does it mean? How's the trustee guided? What did I, as the grantor of the trust, have in mind? And now often you've chose the trustee because you trust their judgment and hopefully you share values. But that's 20 years from now, who knows who that trustee is going to be if they resign and somebody else takes over, and you named your lawyer and they're long retired, and someone you never heard of is the trustee. So I think it's important. I think it doesn't happen enough that you give more guidance. Now you can be very specific in the trust. I mean, sometimes trusts are very specific, saying I want to pay for the down payment for my grandchildren's homes, or this trust is only for education and healthcare, and not for anything else. But I think it's also very useful to have a side letter to the trustee, a memorandum of intent, telling the trustee, current or future, what the purpose of the trust is. And this is especially important in special needs trusts, where how the funds are used can really affect the beneficiary's life. We urge our clients to write such letters to the trustee. So that's the basics of trust in about half an hour. You got it all. But if you don't think you have it all, first of all, we'll open things up to Q&A now. And here's some resources. The best, you can certainly buy the book. It's on Amazon and the library. And I have the other book, Get Your Ducks in a Row, which is all about estate planning in general. And always contact us. But if you have questions on my askharry.info site, I just answer questions, and I don't charge for that. So I posted, I haven't posted them all, but so far I posted 499 questions and answers. So that someone else might have asked the question, and the answer might be there. But if it's not, put in your question, and I'll do my best to respond. So let's see.
Thanks so much, Harry. Can you hear me?
Yeah. Okay.
I was trying to sort of categorize the questions as they came in. So first, a few questions about setup. How much should it cost to set up a trust? How's it done? Is it a legal document? Do you have to register with the state? Those kind of things.
Great questions. So in some ways a little too informal. So a trust is a document. They're often very long. There's a lot of boilerplate in them. Lawyers have a tendency, whenever they run into a problem, to add a clause to their document, whether it's a trust or something else. So over time, they accrete more and more clauses to deal with more and more issues, which they might have run into in their practice just once, but it's in there. So we actually, in our trusts, we single space the boilerplate, and we double space the front part, and that's what you should really read. That says who's the trustee, what are their obligations, what are the standards for making distributions, who can replace trustees, all the issues we were just talking about. But it's just a document. It's a piece of paper. It's really an agreement. Sometimes they're called trust agreements between the trustees and the grantor. And the trustees need to sign it, and the grantor needs to sign it. And sometimes the trustees and the grantors are the same people, and they can sign it once or sign it twice in both roles. And then it's set up, and it does not need to be recorded anywhere, except if there's real estate going into it. Then it still doesn't have to be recorded. In the past, when I was younger, it did. but they changed that rule. And so now all you need to do is record a certificate of trustee with the registry of deeds where the property is. And that there's a form for that. And they kind of say, who are the trustees? They actually don't say the property, but who are the trustees? Who are successor trustees? A number of pieces of information you have to record at the registry, but you don't have to record the whole trust.
Thank you. When you create a trust, do you have to fund it? Is there a minimum amount of assets that you put in?
So you don't have to fund it. Technically, if it's one for estate planning, you don't have to fund it, and it gets funded. Sometimes we have what's called a pour over will. So the will says my estate goes to my trust, and and that's when it gets funded. Let me just get a sip of water here. But technically, the trust doesn't exist until, if it's not part of an estate plan, it doesn't exist until there's actually an asset in it. And that could be $10. So sometimes you see old trusts that might even have a $10 bill attached to it as a funding. But that seems like it's kind of one of those, I don't know. We don't do that anymore.
Okay. How much does it cost to set up a trust?
So there's a huge range. Now you can go online. It's going to cost you a few $100 to do it. And if you use a legal Zoom or Rocket Lawyer, something like that. But it could be in the many thousands. A lot depends on what you're using it for. So a simple revocable trust that just says it's for my benefit while I'm alive, and when I can no longer manage my affairs, my sister Betty is going to become the trustee, and when I die, everything goes to the Wayland Library. Isn't going to cost so much, but if it's going to be used for estate tax planning, for creditor protection purposes, special needs planning, long-term care planning, all these things that make it more complicated, it's going to cost more. So, and usually they're done as part of an overall plan. So you're getting the not just the trust, but you're getting the will, power of attorney, healthcare proxy, help with funding the trust. So I'd say anywhere from $2,000, or in really complex cases, $12,000, but probably most somewhere like halfway in between.
Okay, thank you. So that's the cost to create the trust, and then I think you sort of touched on this, but the question is, what are the costs on the back end after you die?
So hopefully it'll save money, because you'll avoid probate. And the other thing that I think saves the most money and trouble I alluded to earlier is the act of funding the trust certainly makes the lives of your heirs or your fiduciaries, if you become incapacitated, a lot easier, because we find that a lot of people have a lot of accounts in a lot of places, and often they've lost some track of them. And if they're trying to get everything into the trust, we usually advise they set up a trust account at a bank or at Fidelity or at some institution and transfer everything in there. And then when they've done that, that's going to basically mean a lot of work that that no one's going to have to do after they pass away. And if you got a lawyer or an accountant or somebody like that doing it after you passed away, that's going to add a lot to the probate cost. So it's not as much. Probate doesn't have to be so expensive if things are simple, but the act of setting up the trust avoids some of the probate costs, but I think it more just simplifies things for whoever's going to manage stuff when you die.
Okay. I think this question is, you talked about setting up trusts in different states. Are there states that do not tax estates?
Yes. So Massachusetts has the lowest estate tax threshold in the country, tied with Oregon at $1 million. And then I'm sure there's probably about a dozen states that have estate taxes, all at higher levels, and then the rest of the states that don't. The federal estate tax level threshold right now is $12 million, and for couples, $24 million. So if you got more than that, then you should hire a downtown firm to do your planning. If you don't, you shouldn't have to worry about the federal estate tax, though that's all going to be cut in half in 2026. So hopefully hopefully that everyone on this call will be alive in 2026, and then the threshold will be a 6 million adjusted for inflation and 12 million for a couple. So it might bring in a few more people on the federal side. But in terms of using trusts, so if you pass away as a Massachusetts resident, all of your property other than real estate in other states will be subject to estate tax in Massachusetts. And if you pass away as a resident of another state, then only your Massachusetts real estate will be subject to Massachusetts estate tax. And it gets a little complicated. There's some prorating going on, but that's basically how it works. And a trust does not really help one way or the other on those rules. So it doesn't exclude your Massachusetts property if you were a resident of New York, and it doesn't what's the other way? If you're a resident of Massachusetts, your property in New York isn't going to be taxed anyway, so the trust doesn't make any difference.
Okay. So a few questions about management of the trust. A couple about trustees. This is a question someone posted, if they're co-trustees, a professional and a non-professional, can they both charge a fee? Should they split the fee, or does the trust get charged more?
The trust, if they both charge a fee, the trust will get charged more. The professional is probably going to charge whatever the professional is going to charge. When we have cases like that, we usually try to have a relatively low fee for the family member trustee. So it's an additional charge, and we don't want to charge the trust too much. And hopefully the family member isn't going to have to do too much heavy lifting, since the professional's doing the bulk of the work.
Okay. And are there professionals who charge an hourly fee instead of a percentage to administer the trust?
I think when lawyers do it, if they're not part of a big firm with a big trust practice, then they often charge by the hour.
Okay. This is the technical one. If real estate is placed into an irrevocable trust, what is the level of liability to the trustees or beneficiaries in the event of a claim against that property, like a personal injury claim? Is that something a trust protector does?
So I'm not sure if are you asking, is the trustee liable?
Yes, that's the question.
So the trustee will not be personally liable unless they've kind of really done something wrong. So the trustee, yeah, I mean, let me think this through. So if the house is in an irrevocable trust and the trust is sued, yeah, I don't think that the trustee is going to get sued. I mean, if they're managing it, however, and they really screw up, I mean, I don't know that the trust would protect, say you had your house in an irrevocable trust and you're the trustee, and you had a big party with high school kids and they drank a lot and had a big accident, you got sued. The trust is probably not going to protect you because it's from that point of view. But if you're an independent trustee and you're managing some property, something happens, unless you've done something really wrong, I think you're protected. Okay. In any case, make sure it's insured.
So here's the opposite question. What is the advantage to titling, not opposite question, sorry, related. What is the advantage to titling your home in a trust?
Well, I think, so it depends what you're trying to accomplish. So it avoids probate. If you become incapacitated, somebody else can manage it for you, and then it makes sure that if you want to people put their homes in trust for long-term care planning purposes, so that it doesn't have to be spent down if you need mass health to pay for your care, or it's not subject to estate recovery when you pass away. So those are the main reasons. When we have younger couples who are doing really often estate tax planning and setting up trusts, we often don't put their home into the trust, because if they refinance, they would usually have to remove the house from the trust, put it back in their name, and then put it back in the trust. And given that they're young and the house may be in joint names anyway, we often don't put the house in the trust. But if it's an older couple, they paid off their mortgage and are unlikely to borrow on the house, then we'd be more likely to put it into the trust.
Okay. Is there a significant tax savings for the beneficiaries with a trust rather than just a will?
No.
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 So then what is the benefit of avoiding probate?
It's really the cost of filings with the probate court, and it really avoids delay. Because in order to, if assets, I mean, a lot of assets don't go through probate today anyway. So if it has a named beneficiary, it has a joint owner, if it's transferred to a death account, it's not going to go through probate. And which is very ironic in a lot of ways, because there are a lot of formalities in the law around wills and a lot less formality around all these other ways of passing on property that have superseded wills in a lot of cases. But if assets are just in your name without a named beneficiary and you die, then someone has to be named as your executor or administrator by the court to gain access to the assets, and that can sometimes take time. These days, the courts are incredibly backed up. They have to, there are various accountings they have to file with the court that are just unnecessary. Now, they're protective to some extent because it makes things more transparent. So if someone doesn't trust the person who's managing the estate, they have some protection by going to court, or the requirements of filing these reports in court provide protection. But if that's an issue, you may want to stick with probate, no matter the cost and how cumbersome it is. But if that's not an issue, it's just going to be a lot quicker and easier to avoid probate, and trust is a good way to do it. And one of the reasons I prefer trusts to just naming beneficiaries is that naming beneficiaries is piecemeal. And we often see situations where people have named beneficiaries and their circumstances have changed, and then they named other beneficiaries to other accounts or other insurance policies or for other 401k plans, and things just go in different directions. And with a trust or will, but a trust has the other advantages, you say what's going to happen. Everything's going to be divided in thirds or whatever percentage you want, rather than kind of the different beneficiary designations saying what happens to every different asset, which ends up with results which you never know after the person has died whether that's what they intended or not.
Mm-hmm. Okay, we have a few more. Let's see. The question is phrased, is it possible to create a trust for mass health eligibility where the donor and the beneficiary are the same person? So I think they're asking, can I put my assets in trust in order to become eligible for mass health?
Yeah, you can. But you can be the beneficiary. Well, there's a couple different things. So you can be the beneficiary in terms of having a right to income and having a right to live in real estate that's owned by the trust, but you can't have a right to the principal. So you can't have, so say you put a house in the trust, you could still live in the house. And then if you rented out the house, you could receive the rental income. But if the house were sold, you couldn't receive a distribution from the principal. of
Yeah.
in the trust. And there's a 5-year wait. So when you create this trust, you have 5 years to wait before you can get mass health. It's a penalty, called a kind of a penalty period or waiting period. Now, the exception to this, there are a couple exceptions to this, which fall under statutory exceptions. So they're called D4A or D4C trusts, referring to the statutes. So if you're disabled and under the age of 65, you can create a trust and be the beneficiary of the principal as well. But the trade-off is when you pass away, that trust is subject to claim by the state to recover whatever it's paid for your care. So they're called estate recovery. And if you're over 65, so at any age, you can also transfer assets into what's called a pooled disability trust, and get mass health, and there's no waiting period, and be the beneficiary. And these are run by nonprofits. But again, there's that payback provision when you pass away.
Okay. We just had a good foundation question come in. What are the differing responsibilities of an executor of a will versus a trustee of a trust? Does the executor, who is not a trustee, have any responsibilities relative to real estate owned by the trust?
So, so the trustee is only responsible for the property in the trust. The executor is responsible for basically all the property that's not in the trust. But the executor also has a lot of other responsibilities, the kind of doing the final income tax return, paying any debts that are left at death, cleaning out the house or apartment. I mean, it's a lot of work to be an executor, and distributing the tangible assets. And in terms of kind of them interacting, if they're different people, the issue comes to play mostly if there's estate tax due. So you would want the estate tax to be paid pro rata for the property in the trust and the property outside of the trust, each paying their fair share. But depending on what the trust says, the trust itself might not have an obligation to pay that, or just to contribute. But hopefully it will. And then again, that's where you get into the boilerplate. It should cover that.
Okay. I think this is related. So in Massachusetts, estate tax with the cap of 1 million, does that limit include money and assets which are outside the trust as well as in the trust altogether?
Yeah, it includes everything.
Yeah. Okay. Folks can feel free also to unmute if you have a question. I have a few more. They're getting really specific though, so I'm trying to find the general ones.
The specific ones you might want to put on askcarrie.info.
Yeah, askcarrie.info. I have a couple about kinds of trusts. What's the difference between an AB trust and an ABC trust? And the other one is, what's a first-party trust versus a third-party trust?
Okay, I'll answer the second one first, because it's simpler.
Okay. So
first-party trust is a trust you create for your own benefit, and a third-party trust is one you create for somebody else. And that's very significant both in the mass health and special needs planning world and in the creditor protection world. The rules are somewhat similar. So as I said earlier, for the most part, you can't create a trust for yourself and have it creditor protected and still have access to the principal. And you can't create a trust for yourself and have access to the principal and have it sheltered for mass health or SSI purposes, except for those two statutory exceptions. But you can create a trust for someone else, a third-party trust, and have the funds totally available to the beneficiary, and they'll still be protected from creditors, and they will still be not counted in determining their eligibility for mass health or SSI. So that's where the first and third party comes in. Now, A and B trusts and ABC trusts. Well, let's first talk about A and B trusts. So they're all the same. You also might have heard, whoever wrote that might have heard of credit shelter trusts, credit shelter and marital trusts, and also Q-tip trusts. And these are all trusts designed for estate tax purposes. So the estate tax threshold in Massachusetts is $1 million, And if and there's no tax on anything you give to your spouse. So if a husband and wife have $2 million and husband dies first, which is how it usually works, and leaves everything to the spouse, there will be no tax when he dies. But then if she then has $2 million and dies, then she'll have a tax on that because it'll be $2 million over the threshold. So if instead they separate their assets between the two of them, and husband, they both, since we don't really know for sure who's going to die first, they both create the same trust. But let's say husband creates this trust. He creates what's called a credit shelter trust. So he says, the first $1 million in this trust is going to stay in trust for my wife or my husband, I guess, and it'll be written in a way that the surviving spouse doesn't own it for tax purposes. So he or she can be the beneficiary of the trust, but it won't be in her estate or his estate when the surviving spouse dies. So then you have this $1 million that's been sheltered from taxation, and it could even grow. If the stock market continues to go haywire, and it's $2 million when the surviving spouse dies, it won't be taxed, and that's a credit shelter trust.
But she can access that money?
Yep.
Okay.
There's some limitations, but they're pretty minimal. I remember I mentioned the HEM standard, health, education, maintenance, and support. That's actually a tax provision. So the surviving spouse can use it for their health, education, maintenance, and support. So maybe you might argue they don't need a yacht or that trip around the world, but just about anything else, if they need it, it's there. And so that's a credit shelter trust. Now let's say we had we talked about a couple with $2 million and they separated, so it's $1 million each. But let's say they had $3 million and the husband dies first and he's got $2 million. Well, then the trust is going to be written so that $2 million is actually split into 2 shares. And the first $1 million is going to be in this credit shelter share, and the other $1 million is going to be in this marital share. And in the second half will be taxed when the surviving spouse dies, but it won't be taxed again because of the marital deduction when the first spouse dies. So that's why it's often called an A and B trust. So the A share is the credit shelter share. The B share is the marital or non-credit sheltered share. Now, then the question was about an A, B, and C trust, and we don't have to worry about C so much anymore. But back when the federal threshold was also at $1 million, and sometimes it'd be not that long before that, it was at 600,000. There were reasons to have shares that got different treatment for Massachusetts and for federal estate tax purposes. Now, I mentioned Q-tip trust. That's another way of doing this whole thing. So with a Q-tip trust, it kind of, rather than setting out the A, B, and potentially C share in the trust, it kind of leaves it up to the trustee and the executor to figure out, after the first spouse dies, how best to split up the assets and what's the most favorable tax treatment. So more than you want to know, I'm sure.
All right, we've had 2 questions about IRAs. So do you recommend IRA accounts be in a trust? And the second question is, does an IRA with trust as a designated beneficiary go through probate?
So, so first of all, you cannot put your own IRA into a trust, but you can make a trust the designated beneficiary. And if you do that, it does not go through probate. Now, so there are advantages and disadvantages to using a trust. It's more complicated to use a trust. So we often just try to avoid the complication by not making the trust the beneficiary. So unless you have a reason to use a trust, you probably wouldn't. But there are reasons. So that provides creditor protection, as we talked about before. It can, especially if you're in a second marriage, you may want to make sure that the funds are sheltered. If there's money going to somebody with special needs, you'll want to use a trust. And there's another, well, actually this wasn't a case, it was a case in our office that we wrote a blog post about, where we kind of wish this woman had used a trust. So she had this, in this case, this woman had made her nephew the beneficiary of her IRA, and she died at a relatively young age, and she was relatively well off, and he was a minor, and now he's 17, and he doesn't know about that. He's now has over $1 million coming to him at age 18, and the parents are a little nervous about that. So they came to see one of my partners to talk about this, because he's reached the age of majority, and all of a sudden he's got, I'm not sure what it was, but $1.3 million in an IRA that he can control. And further, after his aunt died, his parents had another child, so he has a sister who's getting nothing.
Right.
So if you're going to name a minor as a beneficiary, use a trust.
A question about the new secure law. What is the broad meaning of that?
So that's just as if our lives weren't complicated enough. The Secure Act changed a lot of the rules about IRAs and 401k plans and beneficiaries. So the main thing it did is it got rid of the so-called stretch in most cases. So I'm drawing a blank on what the years were, but if you inherited an IRA before the passage of the Secure Act, you had what was called an inherited IRA, and you had to start taking distributions at whatever age, no matter your age. And at that time, the required distributions for your own IRAs would have been 70.5. Now it's now 72. That's one change of the Secure Act. But no matter your age, if you inherited an IRA, you had to start taking distributions, but they could be based on your own life expectancy. So if you're 40 years old and you're likely to live at least another 40 years, or let's say 50 to make it simple, then you only have to take out 2% per year. Because you can stretch it out. And of course, when you take it out, you got to pay taxes on it, and people want to postpone that as long as possible. So the Secure Act got rid of that for most people. So it didn't affect any existing inherited IRAs. They all continue under the old rules. But now you basically have 10 years to take the money out, not your lifetime. Exceptions are if you're a surviving spouse, if you have special needs, and if you and I think if you're more or less than, I should know this, more or less than 10 years older or younger than the decedent, and if you're under the age of majority, then the 10 years doesn't begin until you reach the age of majority.
Okay. Thank you. Okay. I think we have time for maybe 2 more. I have a couple more, unless anyone wants to unmute and ask their question. I don't see any unmuting, so I will ask this one. Are there trust structures which allow you to direct your assets to beneficiaries while living and then take back the assets upon their passing to distribute again to other beneficiaries? I think the answer is no.
Well, I mean, I guess there could be. So you're alive, you're saying. You want to create a trust for somebody else. But you want to have control, assuming you survive them, what happens to those assets.
Yes, I believe so, yeah.
Well, certainly, I mean, you can create a trust and just retain those powers. There may be different If you're trying to get it out of your estate for tax purposes, that won't work, because that'll be a retention of power that will keep it in your estate for tax purposes. You can give a trust protector that right, and then perhaps they'll do what you ask them to do, though they won't be legally bound to. And you could have what's called a testamentary power of appointment. So you could say that you can redirect through your will, you can redirect who's going to get the property in the trust. So your will would reference back to the trust. So it wouldn't be a testamentary trust, because the trust wouldn't be in the will, but the will could, by reference, say what's going to happen to the trust.
Okay. If that didn't answer your question, yeah. Okay. I'm just looking for a more general one to end with, and they just get more and more specific. So,
oh, yeah.
All right, I'll just do one more. This is a simple one, I believe. Oh, sorry, wait a minute. Okay. If an adult child lives with you and you don't have a spouse or other children, can the house simply be willed to the adult child without using a trust?
Yeah, you could definitely do that. You just have probate. You may actually, there may be situations where you just want to put the house in joint names in order to avoid probate. And for mass health purposes, you may want to avoid probate. So if you only have one heir, and you trust that heir, and they're not going to, and they don't have creditor issues or benefits issues themselves, sometimes just joint accounts is the easiest way to go.
Okay. All right, last question. And this is pretty general, I believe. When should assets be named or funded to a trust as opposed to staying with the individual owner?
So I think kind of when you get into your 50s and 60s is what I would say. I mean, it is some trouble to get all your accounts and get organized and get all your accounts into a trust. So unless there's an overriding reason to do it, you may just want to put it off until a later date. If you are doing tax planning, however, you do need to separate the assets so that with a married couple, so that they're half and half. And so as long as you're doing that, you may want to fund the trust at that point. I see Regina has a hand up.
Oh, go for it, Regina.
Yes, I wanted to ask a question regarding testamentary trusts that are created inside of a will, especially with beneficiaries. So if you have minors and you create this testamentary trust inside of your will, you pass with real assets and some additional assets that are not titled in the name of the trust. I'm assuming those would then have to go into an estate account or through probate into an estate account, be taxed at that level, and then they would move into the testamentary trust. I'm thinking that's the way they would go. And then would there be, say there's 2 children, would there be tax identification EINs for each of those? Would they kind of branch off into each of their own trusts if there are 2 children?
So always the lawyerly answer is it depends.
Okay.
So on paper, it has to go through the estate into the trust.
Okay.
But if there's no real reason to kind of formally open an account for the estate and then then put everything in it and then split it up and move it into the trust, you maybe sort of kind of skip that step, even though the state documents might say that you did it, you may save a little trouble, and you may be able to, depending on the circumstances, the timing, avoid having to do an estate tax return, estate income tax return. So that depends. So in terms of the continuing trust, whether you need separate tax ID numbers.
Each child.
Yeah. So you're saying the funds are going to be managed totally separately for the 2?
Well, the trusts would be, I'm working with a trust right now where they're going to be separated out for each of the children. So the funds will be divided and they'll be separated out for each of the children. So I'm assuming there'd have to be a separate trust created for each child.
Easier that way. I mean, you could probably do it either way, but that might be easier. So our typical trust, I mean, I don't know how old the children are, but we, for minor children, we usually create what lawyers call a pot trust. So we say until the youngest child, unless there's a big range of ages in children, but until the youngest child reaches age 25, everything is going to be kept as a single fund. Gotcha. And spent for the children, so that you don't. So I mean, it could be that one kid has greater needs, or goes to a more expensive school, or who knows what, and they kind of really be charged for that, because it would all be coming from the family anyway.
Right.
So that's kind of our usual approach.
Thank you, and I want to thank you for your podcast. We really enjoy listening to the Ask Harry podcast. So
thank you.
Keep doing that work. Appreciate it.
Okay, will do.
Any more questions? I see Ken.
Ken.
His hand. Go for it, Ken.
Hi, I wasn't sure how to raise my hand electronically here.
Seems to have worked.
So I'm doing it manually. Hi.
Hi.
I have a question regarding gifting. I know that you can gift, I believe that's as much as $16,000 to each child or to each family member.
Yeah.
But suppose you want to give them some sort of a tangible asset up to that amount of money. I was told that there's that they actually have to pay a 28% tax on it. Can you perhaps shed some light on that?
Probably what you're talking about is what happens if they sell it. So,
yes,
right. So, this is all about capital gains. So, so I'm sure want to give us an example of what kind of gift you're talking about, or what kind of property?
Jewelry, let's say.
Okay, so let's say it's jewelry, and let's say it's I don't know, I'll say it's worth $30,000. So if you give it to them while you're alive, then their basis for tax purposes is the same basis you have. So if you bought it for $3,000 and it's now worth $30,000, and you sell it and you have $27,000 a gain, you would pay a tax of up to 28% on that gain.
Well, maybe I inherited it from somebody that's been in the family for 100 years or something, and
right.
So nobody knows who paid what for it.
Right. So then the basis is the value on the date you inherited it. And so if that, again, we'll say it was $3,000, whatever was on the inventory in that person's estate. And then if you give it to your kids and they sell it, they'll have that capital gain. But if instead they inherit it from you, then the basis becomes the value on the date of death. So if it was worth $30,000 when you die and they sell for $30,000, then they have no capital gain. So that's a reason not to make. So basically, if you have a choice, it's better not to give appreciated assets and to keep those, and to give non-appreciated assets. Or if they're never going to sell it, it doesn't matter. But it's the selling that incurs the capital gains.
Thank you.
Welcome.
Anyone else? A lot of info here. And so Harry has a podcast, and you can find him at askharry.info, and also margolisbloom.com. And I want to say thank you so much to Harry for being here tonight.
Yeah, thank you all for joining us and sticking around.
Everybody have a great night.
Thank you.
Bye.
Bye, everybody.